First things first, let's go to the Honorable Mukasa Mbide. Counsel Mbide, now, let's try to understand what in the first place do you make of the grounds that the Law Council based on to deny Martha Karua a practicing certificate?
First of all, I do not find the grounds, particularly when you give regard to the dichotomy of whether or not a material to be practiced in is either criminal or civil. I don't think those are grounds that would be relied on. What one would say is, first of all, there is sluggishness within the East African community in terms of adopting a cross-border Professional Services Act, which we actually tabled. It had first been tabled as a cross-border legal practice bill, resisted, cross-border professional services bill, which was tabled by me, resisted, and now we have got an Annex 7 of the Common Market Protocol on Professional Services. Legal is not there, but Law Council needed to have taken probably deontological, ethical decision that would be based on the goodwill for purposes that practicing cannot be with regard to whether or not it is criminal or civil, in order to allow the Honorable Martha to practice in Uganda.
Well, Honorable, the same act that is under Article 8, subsection 1 of the Advocates Act says discretionary, not mandatory. What do you have to say about that?
And you see, discretion all over the world follows the law. What Law Council needed to know is that it is not as wide as probably what they would believe, to the extent of extinguishing even the right of fair hearing and the right of an inmate, for example, an accused, for purposes of obtaining legal support that he needs under the African Charter on Human and People's Rights, to which, of course, Uganda is a signatory, and the East African Community Treaty, particularly Article 6D and 72 thereof. So, in my opinion, the Law Council needed a wider consideration of this matter before a decision that is definitely archaic has been taken.
All right, let's now cross over to Counsel Musisi. Counsel, we talk about the law. Does it bar any foreign lawyer from practicing in Uganda?
No, outrightly no. The requirements are clear that the Law Council is only supposed to ascertain whether the person fulfills the conditions. Is the person a practicing advocate in the other country? Is the person attached to a law firm? Those are the minimum requirements. The Law Council seems to create another requirement, which is outside the law, of intention that this is a political matter. Now, advocates or lawyers handle matters for different reasons or motivations. They could handle for political reasons, for economic, for spiritual. So this is outside the law. This is an extra requirement. It's certainly something that should be challenged because it's an abuse of the powers of the council. It's certainly outside what the requirements are.
So then, is it within the ambit of the law for the Law Council to actually introduce in another requirement? Does it make sense?
It's not within the ambit of the Law Council. More so when you're introducing an extra requirement, going towards the intention of the advocate. Now, people have different motivations. So this is clearly an abuse of their powers. If you look at the requirements of the law, they don't seem to have discretion that you can deny on another ground which you can think of. Otherwise, if you are to create or to deny practice on the basis of what the perceived intentions are, it's certainly room for abuse. That is outside their discretionary powers.
Well said. So is it, are there any limitations within the law for a suspect to choose who their lawyer should be?
The only limitation is if the person is qualified. And the person is not limited even to the number of lawyers they may choose. So the issue of legal representation goes also to having a right to counsel of choice. And that goes to the right to a fair hearing under our Constitution, which is one of the non-derogable rights under our Constitution. So fair hearing encompasses having a right to counsel of choice. As it is now, Senior Counsel Martha Karua fulfills the set requirements under the law. She's only denied on the basis of an extra legal requirement, which is set by the council.
Honorable Mbide, so then what does this precedent mean for the East African cooperation and community?
First of all, of course, it gives a very, very bad example. The veracity of Law Council is definitely put to test to the extent that whether they are actually in conformity with the procedure of the East African Community Treaty, particularly on standardization and harmonization of professions. Because those are standard procedures that we already arrived at. Protocols were assigned to that effect, and I would expect law counsel to have put into consideration all of those. Only those would have been the problem for senior counsel Martha Karua to practice in Uganda. They, of course, the introduction of a new arena of discovery, for example, which is actually wide and wild, of whether or not one has got ulterior motives. The motive of practice is practice, and the determination of what happens is definitely by a judicial officer before you. So in my opinion, really, the law counsel needs to definitely make sure that they desist from that kind of behavior, because which ultimately turns it into an institution and an instrument of oppression against judicial service in Uganda.
Honorable Mukasa Mbide, Counsel George Musisi, it's been a pleasure listening to your insights.